5 seconds to go. Start. This appeal arises out of an unfortunate dispute between the appellant number 1 wife and the respondent number 1 husband over the custody of their minor male child Aditya Kiran. This appeal takes an exception to the judgment and order dated 31st August 2021 passed by the learned single judge of the Punjab and Haryana High Court in a petition for habeas corpus filed by the respondent number 1 herein for seeking custody of the minor. The respondent number 1 and the appellant number 1 were married in New York, United States of America, for short USA, on 13th January 2011. The child was born in USA on 21st January 2016. Thus, the child is a citizen of USA by birth and is holding a USA passport. Unfortunately, the child was diagnosed with hydro illness which required surgery. It is the case of the respondent number 1 that as they were not in a position to secure an appointment of a doctor in USA for surgery, it was agreed between the appellant number 1 and the respondent number 1 that the child will undergo surgery at Max Hospital, Saket. As the child is a citizen of USA, consent for international travel with one legal guardian was executed by and between the appellant number 1 and the respondent number 1 on 4th February 2019. The consent was recorded in the said document to enable the child to travel with the mother, the appellant number 1, to India. The consent was executed for the period between 5th February 2019 to 26 September 2019. The consent document recorded that the child will be leaving USA on 5th February 2019 and will be returning back to USA on 26 September 2019. It was further recorded that any changes to this plan shall be discussed and consented to by both the parties. A certificate dated 17th September 2019 issued by Dr. of Max Hospital Saket, New Delhi records that the child underwent a surgery on 14th March 2019. It records that he had examined the child on 12th July 2019 when he found that the child was doing well. Doctor has recorded that the child needs to be reviewed 6 to 7 months post surgery along with a fresh ultrasound and renal scan. It is the case of the respondent number 1 that at the time of surgery he flew down to India. After the surgery, he returned to USA for his work. It is brought on record that the respondent number 1 has a status of permanent resident in USA which is valid up to 16th August 2031. According to the case of the respondent number 1, the appellant number 1 violated the international travel consent by not allowing the minor child to come back to USA by 26 September 2019. Stop.